Hi, welcome to My Court Coach. I'm Jaylyn, and I'm going to be your instructor as we talk about Form DV-140, Child Custody and Visitation Order. This form must be attached to your temporary restraining order or your restraining order after hearing. That means that the court has granted your temporary restraining order and they also agreed to order your child custody and visitation order. So the form can essentially be completed once. You make two separate copies and attach them to the two proposed temporary restraining order and the proposed restraining order after hearing. And when I say proposed, it essentially means that you're completing the forms in hopes that the judge just checks a few boxes and signs off on his or her name. So you want to write the name of the protected person, whether you're the mom, dad, or other, and then the name of the other party, whether they're the abuser or the alleged abuser. You write whether they're the mom, dad, or other. And other could be a legal guardian. That could be somebody that you share a child with. Then the court is going to mirror what you had written in your request for a child custody and visitation order. And so it should have the children's name, the date of birth, who legal custody is going to go to. So legal custody is the one that makes decisions about health, education, overall welfare. The physical custody is who the child is going to live with. And so that needs to be completed because it is going to mirror your request for a domestic violence restraining order. And so you'll likely request legal custody to be sole and physical custody to also be sole. And whether you're the mom, dad, or other, you would be checking off those boxes. If there's more than one other child, then you can use this MC025 and just type in DV-140 and type in the names and date of births and the custody requirements that you are hoping the court would order. And then for other, again, you would type in the same relationship that you would have typed in up here in number 2. So for section 4, it says child visitation is ordered as follows. Again, this is going to mirror your request for the restraining order child custody request. And so it's going to say either no visitation of mom, dad, or the other, or you're going to attach a document that already has a visitation schedule that you've drafted, and you need to write the date of that, or you want the parties to go through mediation. So Family Court Services mediation is offered through the court when you file a request for custody and visitation. That is only typically requested through a family law form F300. So the request for order form, typically when the clerks see that, then they automatically issue a family court services mediation day. If you did request it through your child custody and visitation restraining order, then the clerks or the court might include the mediation date. It depends, and it varies from judge to judge. And so they might include that as part of their court order, and that mediator just assists the party to come up with a visitation schedule. Or you can request visitation until the next court order. So the visitation for mom or dad or other will be, and then you'll have certain weekends and certain weekdays or some other visitation schedule that you would like for the court to follow. And again, you can use this MC025 form up here and type in other visitation and outline what that visitation schedule could look like. You can have that visitation supervised. So if you do click this box, then that means you're requesting the child visitation or exchange to be supervised. And so you would use DV-150 for that. And we would go through that in a separate video. So the responsibility for transportation for the visitation just means the parent that will pick up or take the child or make arrangements for someone else to do so. So how are these exchanges happening? And it could be mom or dad taking the children, picking up the children, or just having a drop-off pickup location, and that address should be a public one, or it could be curbside one of your residences. And if it is curbside one of your residences, then I'm sure there has to be an exception to brief and peaceful contact for the parents to be able to communicate and be able to exchange the children appropriately. But of course, if there's supervised visitations, then your supervisor would be handling that, or at least should be handling that. So travel with children, mom, dad, or the other must have written permission from the other parent or a court order to take the children outside of the state of California, the United States, or other places, usually I write County of San Diego. Then there's the child abduction. If there is a risk that one of the parents will take the children out of California without the other parent's permission, then you check off that box, and then you also complete form DV-145, which is no travel with children, and the court will allow you to not have the children leave the state of California, essentially, due to the risk. And then any other orders that, again, were requested in your child custody and visitation request, then you would go ahead and check off this box and an attachment with the words other orders on there and what your proposed orders are, so that the court can just make sure that they attach that. And if they do not attach it, then it's because they do not grant your other orders. So the court has to make findings that they have the authority to make child custody and visitation orders. And so they do that by just citing this one statement here, that they have to give the other party notice and opportunity to be heard. So the responding party was given notice and opportunity to be heard as provided by the laws in the state of California. You have to identify the country of habitual residence. It's usually the United States of America. I also check off the box other and write County of San Diego, and then penalties for violating this order. So if they violate it, you must be subject to civil or criminal penalties, or both. And then the duration of the visitation or support orders, it says if this form is attached to a DV-130, which is the restraining order after hearing, then custody and visitation orders in this form remain in effect after the restraining orders on DV-130 end, or until they are amended. So this is how you complete the DV-130 form. Again, make sure that you do attach it to your temporary restraining order proposal, as well as your request after restraining order after hearing proposal as well. I hope that you found this helpful, and best of luck.